Good afternoon, everyone, and welcome to our weekly webinar series, providing you with some updates on the coronavirus. First of all, I'd like to extend a warm welcome once again to our clients and friends of the firm. We're pleased to be able to do this. We hope that it's helpful. We've gotten some very favorable feedback from folks regarding it. My name is Pete Jones. I'm a partner in our Syracuse office. Just a couple of notes before we get started. First of all, we've decided to run this through the month of May. You should be, if you're previously registered, automatically registered, but if not, we're going to be sending reminders to folks so that you'll be able to get on a weekly basis for our updates. Secondly, we've got a little survey that we asked you to complete when the webinar is over. That's very helpful for us, so to the extent that you're able to do so, we would appreciate it. And the last thing I just wanted to mention is we are trying to answer your questions throughout as we are able. Some questions are kind of specific to individual operations or businesses. We're not really able to get to those during the webinar. If there's a question we have that we're not able to answer, feel free to reach out to your bond contact and we'll be happy to help you after today's webinar. Okay, we've got a full program today, so we'd like to get started. First up is Mallory Campbell. Mallory's in our New York City office and has been following the unemployment insurance developments very closely. One of the things that we continue to get a lot of questions on are unemployment insurance and the various scenarios that might apply to your different operations and your different situations. So, Mallory, take it away. Mallory's just going to answer some of the most common scenarios that we're seeing.
Thanks, Pete. So as Pete mentioned, I'm an associate in the New York City office, and I'm going to be talking a little bit about actually just 4 issues that we've been seeing related to unemployment. So just a little refresher for everyone so we can kind of get on the same page. The CARES Act expanded unemployment benefits by giving an extra $600 per week to individuals through the end of July. It expanded coverage for unemployment for 13 additional weeks on top of the normal 26 weeks. It extended coverage to individuals that aren't normally eligible, so people that are self-employed or independent contractors who normally aren't eligible for regular unemployment now are covered under this expanded coverage. And there's also a waiver of the 7-day waiting period that people usually have to wait to receive benefits. Next slide, please. So the first issue I want to talk about is how to figure out the weekly benefit rate for individuals. And for the regular unemployment, this is pretty straightforward. It's just a calculation based on past earnings, and the New York Department of Labor actually has, and it's on the slide here, this calculator to kind of estimate the amount you'll receive. But what's a little more confusing is the expanded coverage. So the statute provides that the weekly benefit for those under the expanded coverage is the amount authorized under the unemployment compensation law of the state. So for workers with sufficient wages, this is just the same calculation as the regular unemployment, so you can use that same calculator rate. But for people that do not have sufficient earnings, or maybe they have no wages, so this could be someone who just started working prior to the pandemic. Maybe they just worked for a few weeks before being unemployed and they don't have the sufficient earnings to qualify for regular unemployment. The U.S. Department of Labor provided guidance that there is no minimum monetary requirement for those receiving the expanded coverage. So while under regular employment, there is a certain amount that individuals have to make to be eligible for regular unemployment, there is no minimum requirement under the expanded coverage. So for someone who does not have sufficient wages or has no wages, they should receive 50% of the state's average weekly payment of regular compensation, which is also a little confusing, but luckily the U.S. Department of Labor has provided this figure. So for New York, the amount is $178 per week from January 1 through March 31, 2020, and then $182 per week from April 1 through June 30, 2020. And then also just a reminder that any individual who receives at least $1 of underlying benefits, so whether that is from regular unemployment or through this expanded coverage, is entitled to receive the additional $600. So individuals without the sufficient wage history or with no wage history will receive that 50% minimum amount, the 178 or the 182 plus $600. And then the next slide, please. So another issue I want to talk about is employees who do not want to come back to work. So places might start to reopen soon and employers may be calling back their employees, but I think we've been starting to see this. Employees do not want to come back. A lot of them are probably getting more in unemployment than they would if they came in, so it's kind of understandable. But how does an employer handle this when the employee doesn't want to come back in? So if an individual refuses to return to work because they want to file for unemployment benefits, this is not one of the COVID-19 related reasons listed in the CARES Act, so they would not qualify for unemployment. An individual who chooses to not return to work because they have a general fear of contracting corona, this is also not one of the listed reasons to qualify for unemployment. So when an employer calls back an employee who refuses to come in, they should make sure to listen to the reason why the employee cannot come in. And if the reason is something like general fears, or if it otherwise doesn't fall into one of those listed reasons in the CARES Act, the employer can let the employee know that he or she may not be eligible for unemployment benefits. Next slide, please. So a third issue I want to talk about is part-time employees and alternating work weeks. So in New York, to be eligible for partial unemployment benefits, an employee has to work less than 4 days per week and make less than $504 per week. So employees that are switched from full-time to part-time will receive 3/4 of their full weekly benefit if they work 1 day a week, half of their weekly benefit if they work 2 days per week, 1/4 of their weekly benefit if they work 3 days a week. And as I mentioned, if they work 4 days a week or more, they will not be entitled to any unemployment benefits. But the requirement to earn less than $504 per week can exclude certain employees. So for example, if an employee makes $75,000 per year, and then because of COVID, they have their hours and wages reduced by 20% to $60,000, still be making more than $504 a week and would not be eligible for unemployment benefits. So one solution that an employer can do is to implement this alternating work weeks. So instead of having employees work reduced hours each week, they could work full-time 1 week and then be off the next week. So with the alternating work weeks, employees could receive unemployment benefits on the weeks they're not working. The employee would submit a claim for unemployment, but would only certify to request benefits in the weeks they're not working. So this is an attractive option for employers who want to reduce employees from full-time to part-time, but allowing employees to maximize their compensation. And then the next slide, please. So the last issue I want to talk about is the shared work program. Sometimes it's also called short-term compensation. They're interchangeable. So this is another attractive option for employers. It's a layoff aversion program where an employer reduces the hours for a group of workers, and then the workers receive a reduced unemployment benefit payment. This program can also be used to bring back most or all of furloughed employees. So to participate in this, an employer has to submit a written plan to the unemployment division, and the plan has to reduce hours and corresponding wages by 20 to 60%. And the CARES Act does provide for federal reimbursement of shared work programs from March 27, 2020 through the end of this year. So just in a little example of how this works, it's a little confusing, at least I think so. So if an employee earns $400 a week, and if they were to be totally laid off, they would receive $200 a week in unemployment. The employer decides instead to take part in the shared work program and reduce wages and hours by 20%. Then the employer would be paying employees the $320 So 80% of the $400. And then the employee would also receive $40 in shared work benefits. So the $40 is the 20% of the $200 weekly benefit rate that they would have received if they were totally unemployed. And then also under the CARES Act, these employees would also be entitled to the additional $600. So that's just another attractive option for employers to consider during this time. And that covers some of the biggest concerns we've been seeing, but if you have questions on any of these issues or on other issues related to unemployment, definitely submit some questions and I'll try to get to them at the end. But I'm going to pass it off to Dan now, who's going to provide a litigation update.
Hey, Mallory, before we move on to Dan, just a couple of quick questions that arose. We can knock these off, I think. One question was, if an individual has insufficient wages under the pre-existing rules, are they eligible for unemployment at this time under the CARES Act rules? And I think you already may have touched on that, but can you just cover that real quick?
Yeah, so they would not be eligible for regular unemployment, but they could fall under the expanded coverage as long as they fall into one of the listed COVID-19 related reasons. And then the insufficient wages would just be, they would receive that minimum amount, which was the 182 from April 1 through June 30. And then they would also receive the additional $600.
Okay, second follow-up. Question from somebody about not having basically lost any work time. For folks who have been able to continue to work and receive their full hours and full wages, they would not be eligible for unemployment benefits. The question relates to whether there's any way they could avail themselves of these supplemental benefits. You know, theory being that some people are better off being on unemployment than working. I assume the answer to that is no.
Yeah, there's not really anything you can do if you're totally employed still and receiving your full wages and your full hours. You'd have to be reduced, or if the employer implemented like a shared work program to receive some benefits.
You know, and I think the comment on this is that this is a somewhat imperfect program. I mean, obviously it was put together quickly as part of a relief package, and there are some, you know, competing incentives or perhaps disincentives that are built into the system. So maybe that's the message that we have to share with our employees, that, you know, it's not perfect, but the people who are working have a job and have benefits, and the people who aren't are on unemployment. Okay, let's move on to Dan. Dan's got some updates relative to litigation and what's going on there. Dan Pouts is a partner in our Syracuse office. Take it away, Dan.
Thanks, Pete. Thanks for having me back. I was on this webinar a couple of weeks ago. As Pete mentioned, I'm a trial attorney here in the Syracuse office. And the last time I was here, part of what we talked about was the expectation that there was going to be a significant number of lawsuits that are filed resulting from this COVID-19 crisis. Now, at that time, most of the lawsuits that we were seeing filed were filed on behalf of inmates seeking release from detention facilities, and also, you know, a handful of negligence actions, primarily by people who were on cruise ships where there was an outbreak. Sure enough, here we are 2 weeks later, and as of this morning, there's been about 800, a little more than 800 cases filed in state and federal courts across the country related to COVID-19 issues, about a third of which have been filed in New York State. That number, at least my opinion, is growing rapidly based on the more aggressive advertising that some of these plaintiffs' firms have been doing. The newly filed lawsuits, many of which are filed as class actions, they run the gamut in terms of subject matter and type of industry and size of business, things like that. One example is we've seen a number of lawsuits. There's about 50 of them, just north of 50 lawsuits that have been filed against colleges and universities by students who are seeking refunds for tuition, room and board, and other fees. And the crux of these claims, they're breach of contract claims. And the students are alleging that by providing online instruction and sending them home from campus, that the institutions aren't providing the level of instruction or experience that they're contractually obligated to. Many of the schools, in response to that, have, or proactively have implemented different types of refund policies. But just based on the sheer number of institutions and sheer number of college students across the country, we expect that these cases will continue. And we're talking about hundreds and hundreds of thousands of students potentially pursuing these types of claims. And the most interesting part of these claims is obviously what happens in the fall, i.e. whether students are allowed back on campus, is going to have a tremendous bearing on how these cases march forward. So we're keeping an eye on that. We've also seen a number of lawsuits that have been filed by unions representing employees in many different industries with respect to alleged failure to provide adequate PPE, the personal protective equipment. We've seen these filed by unions representing nurses, public transportation workers, essential retail workers. And in these types of claims, as I reported last time, particularly in New York State, they could be barred by workers' compensation law. But as of now, that issue specifically with respect to COVID-19 hasn't been litigated, but certainly we're going to keep an eye on that. Lastly, a large number of cases, COVID-19 related cases that we've seen filed, arise out of nursing homes. And the last figure I saw, I think, was somewhere around 25,000 people nationwide have died in nursing homes and assisted living facilities as a result of COVID-19. Nearly a quarter of those here in New York State. Because of that, as I'm sure you've read recently, there's been aggressive lobbying efforts in many states seeking some type of legislative protection from liability from these claims. Here in New York, actually, as part of the recently passed budget, there was what's called the Emergency or Disaster Treatment Protection Act that was put into law. And this law, essentially, it shields hospitals, nursing homes, other healthcare facilities from criminal or civil liability, as long as that facility can show that the care was provided as part of a good faith response to the COVID-19 emergency and that it was provided in accordance with state rules. However, one very important part of this legislation is the immunity doesn't apply in situations where there's either intentional harm, gross negligence, or reckless misconduct. Because of that carve-out, we expect that there's going to be a significant amount of litigation with respect to whether a facility's care falls into one of those three exceptions. So again, these are just examples of the types of claims of those 800 that are being filed on a daily basis. From a litigation perspective, the most interesting part of this whole analysis is that many of these legal issues are unprecedented, or at least haven't been tested for many, many decades. This morning, I was looking at potentially relevant principles of contract interpretation, and the cases that you found go back to the polio outbreak. So that just gives you an idea of what we're dealing with here in terms of uncharted waters. I mean, our system of jurisprudence is built largely on precedent, how courts have decided issues of law under similar circumstances. And I think most reasonable people would agree that there haven't been a lot of similar circumstances to what we're in now. So we really don't have any idea how judges or juries are going to decide these. But what we are doing is we're continuously monitoring these new filings. We're continuously looking for new decisions and relevant legislative action. And we're prepared to assist our clients, many of whom I'm sure you never expected to be in this situation. But we're here to help. We're here to share our expertise and share our knowledge with you. And if I could, Pete, one more just last point of general interest. As many of you know, New York State courts, and courts everywhere, quite frankly, have significantly curtailed their activities over the last couple of months. Here in New York, in state court, we're still not even allowed to file or commence a new action unless it meets the definition of an essential filing, an essential action. But the good news from our perspective is there's movement in the right direction of reopening. Just yesterday, the chief administrative judge issued an order allowing certain filings to be made in existing cases. For example, motions in cases that were filed pre-shutdown. We've also seen courts adapt tremendously well to conducting and implementing virtual operations. This morning included, and over the course of the last couple of weeks, I participated in a number of court conferences and motion arguments, both via Skype and telephone. And it's gone way smoother than I think any of us expected. The court has done a tremendous job in adapting and implementing. And the major takeaway that I've had from these interactions with the court, the virtual interactions, is judges are expecting us to continue to move cases forward to the extent that we can. One example of this has been the possibility of conducting depositions virtually. That's something that 2 months ago, many of us would have never considered or even thought of. But these are changes that we're going to have to get used to. And for those of you certainly who are currently engaged in a litigated matter, you should talk to your attorney about this and begin making preparations to adapt to this new normal, because this is, I know it sounds cliche, but this is how things are going to be, particularly in the world of litigation, for the foreseeable future. So we all need to be aware of that, and we all need to be willing to adapt. So thanks again for your time. I appreciate the opportunity to present, and certainly if you have any questions or need to discuss anything that I touched on, please do not hesitate to reach out. My contact information is on the screen. And thank you again, and I wish you all continued good health.
Hey, Dan, before we let you go, let me just take a stab at kind of, high-level summary of the principles here. So I think what you outlined is that the usual rules with respect to liability, damages, things like that would apply. The difficulty here is that we've got a unique set of circumstances. The word unprecedented has been used, but frankly, it's pretty darn unique, if not completely unprecedented. And so what you're seeing is, interesting doctrines or interesting applications of the doctrines based upon these fact circumstances, and we're not quite sure exactly whether the courts are going to accept these applications or not. Is that kind of a layman's summary of the negligence issue?
That's exactly right, Pete. And another example that may resonate, I think, with more people may be in the world of contract law. Many of us have either heard of or seen a provision in a contract called a force majeure provision, which is an act of God. So under certain circumstances, the contracting party is not obligated to fulfill their certain obligations, contractual obligations, because of an act of God. And now under these circumstances, the question becomes, will this be deemed by courts to be an act of God? In which case, will there be certain contractual obligations that parties aren't required to comply with? So that's just one example of an existing legal doctrine that we're all know and we're all familiar with, but we just don't know how that doctrine is going to be applied and interpreted in light of these circumstances.
Good, thank you, appreciate that. Let's turn now to Adam. Adam has been heading up our efforts in the reopening area, kind of coordinating a multidisciplinary team. Adam Masterleo is a member in our Syracuse office, in our labor practice group, with a lot of litigation experience. Adam, take it away.
Thank you, Pete. Like Dan, I was here a couple of weeks ago, so I appreciate the opportunity to be back. We have been watching the governor very closely, and I think we all realize that we're getting closer to opening. He continues to provide additional details, additional specifics that the state is going to be looking for. We're not there yet, but we're getting closer. So we have talked quite a bit about reopening and workplace safety plans. I want to shift away from that a little bit and talk more about other issues that are going to be arising as part of the reopening. But with respect to workplace safety plans, I did want to make one comment. We now know that OSHA is starting to investigate cases of COVID-19 in the workplace. And we know that they are looking at things like what risk assessments employers have conducted, what safety measures they've put into place, what PPE they're providing, what cleaning and disinfecting they're using. So we know that OSHA is considering these things. It's all the more reason to have a workplace safety plan in place, and I would just encourage you to do that. I want to focus a little more today on other issues involved with reopening, more specifically, repopulating a workforce. If you're closed, how are you going to bring back your employees? The first suggestion that we have is that you really need to make sure that you plan this out. Put a team of people in place, or if you're smaller, have a single person whose responsibility it is to figure out how you're going to do this. The analysis should begin with examining whether or not there are any contractual obligations that you have that tell you how you need to bring people back. So do you have a collective bargaining agreement that talks about bringing people back after layoffs? That may very well control how you're going to have to bring people back following the furlough. If you have an existing policy in place, you need to review that. Figure out whether or not that dictates how you're going to bring people back. Now, another consideration, if you're going to bring people back, how are you going to do that? Is it going to be in a phased manner? Are you going to have a little bit at a time, trickle people back? Are you going to do 25% to 50 to 100? Or are you going to try to bring people back all at once? We know that in certain industries, that's not going to be possible because the state is going to most likely regulate how you bring people back. But you need to make a decision about the manner in which you're going to bring people back. If you're only going to bring certain people back or a smaller percentage of people back first, the question arises, how do you do that? And I saw a question already someone had sent in, and that was about whether or not, or how you make sure that you're not bringing people back in a way that is discriminatory. That's a great question, and that's something you should be thinking about. The answer is you need to have a plan in place that uses objective criteria. So make sure that you're bringing people back in a way that has nothing to do with any protected characteristic. That could be based upon seniority or some other non-discriminatory basis, but you have to make sure you think about it and you have a plan in place. Another issue to consider is what documentation or proof is going to be needed to substantiate your decision on how you're going to bring people back. And our recommendation is that you have it written down. You have a policy in place or a plan in place, a procedure in place that says, here is how we're going to bring people back. These are the steps we're going to follow. Dan was talking about liability just a minute ago, and documentation is obviously a key in addressing and mitigating your risk of liability, and it is definitely a necessary thing in this case as well, making sure you document how you're going to bring people back. You should also conduct an analysis of what your objective criteria is doing. So run through, say you want to bring people back in this manner. Well, work it through before you actually do it. See who's going to be brought back, and if there are any potential problems. Does it look like you're bringing back more of one protected category than another, or one category of people and not another? And try to adjust your plan accordingly. After you've decided the method of bringing people back, how you're going to do it, you need to communicate that with your employees. So you need to decide, are you going to send out a mass company-wide email that lays out your plan for bringing people back? Are you going to tell your employees how you are going about bringing people back and what criteria you are using? This is part of a communication plan that you'll need to have in place. How are you going to communicate with individual employees that they're being recalled? Another issue that you'll have to consider is how long are you going to give your employees to respond to an offer of recall? So let's say that you're going to bring back 25% of your workforce, and you communicate to those 25%, we would like you to come back, here are going to be your shifts, here's when you're expected to come to work. You need to set a time frame within which they have to respond to that offer of recall. And that has to be very clear in the communication that you provide. Now, we've been getting a lot of questions about what are you going to do when an employee is either unwilling or unable to return to work after they've been recalled? And this is a great question. This will need to be addressed in your procedure or policy. So for example, what if an employee has a COVID-related reason for not coming back? Either they are under a quarantine order or they have childcare issues that prevents them from coming back. What are you going to do in that situation? How are you going to respond to an employee who says they are just generally afraid to come back? Mallory talked about it in the first segment. That's not going to be a justification for receiving unemployment benefits, but how are you as the employer going to respond? There are some statutory considerations that you need to take account of. For example, OSHA has a provision that allows an employee not to work if they believe they're in imminent danger. Now that is a defined term and it's difficult to interpret. It's not going to apply in the majority of circumstances, but it's something that you should be aware of. Similarly, is an employee protected by the Americans with Disabilities Act and therefore not willing to come back? So those are things that you have to consider and think about when you're forming your procedure. Now, there are also non-COVID related reasons, or if an employee wants to collect unemployment. Now, wanting to collect unemployment is obviously not a reasonable reason or good reason for an employee to refuse a callback order. Now, finally, you'll have to consider when you're bringing employees back, how are you going to manage higher absences? So let's say that you are an employer, you bring people back, you have a workplace safety plan in place, and you are screening employees for fevers, just as an example. And you get one day where 20% of your workforce has a fever and you have to send them home. Your plan should address what you're going to do in that situation. Can you cross-train? For example, one solution might be cross-training other employees to perform lots of different tasks so that they could be called to fill in. Or if you increase part-time opportunities for your employees to pick up shifts where others are unavailable. These are things that you need to consider. So making sure that your procedure addresses how to deal with these potentially large absences so that you can maintain your workforce. So Pete, those are just some of the issues associated with reopening and bringing people back to work.
Adam, thanks. Appreciate it. There's a lot of angles to that. And I think you're, just to put it in context, I think you are focused, with the comments you just made are really focused on the individual workplace. We're going to turn to Katie now. Katie Anderson is in our Albany office. She's been following the events or the updates on a daily basis from Albany for us, but she's also got some comments, I think, today more globally on reopening and the governor's recent, I'll call them indicators, because I don't think we've got concrete guidance yet. Katie, take it away.
All right, it's Katie's time, Katie's corner, as I fondly called it the other week. If we could go to the next slide, Kathy, that'd be great. So this slide keeps popping up, but it's worth looking at just so you can really understand what New York State looks like. You have all of these economic development regions in New York State, and this is just your reference point going forward for that. What we're going to see is likely reopenings that will occur in areas like the Finger Lakes, which includes Rochester, notably, the Southern Tier, Central New York, Mohawk Valley, and the North Country. But don't worry, I'll talk more about that in a little bit. If we could go to the next slide, that'd be great. So there's going to be this regional approach to reopening. And these guidelines are, I believe Hermes spoke about them last week. And this is really just a rough outline of what reopening will look like in each of those regions. And the point of reopening is it's going to be opening the valve slowly. That's the analogy the governor keeps using. I think that visual that's on the screen is very informative as to how reopening is going to occur. We reopen slowly, and if the hospitalization rate or infection rate in an area begins to get to untenable levels, which we'll talk about those levels in a few minutes, then that has to obviously close the valve more. this is going to be a long process. This is not going to be the pause order is up on May 15th and everything opens. That's not going to be the case. We are going to likely see a more refined type of pause order, but it likely won't be called pause. It'll be called something else, I'm sure. And it will be, based on this criteria. And it will be based, for a visualization of that criteria. Let's go to the next slide. So this is from the governor's press conference yesterday, this table. And so what this shows is what regions in New York are closest to reopening and how regions in New York State will be reopening. So the top row are the 7 metrics that each region will have to follow for reopening. The 5 that I mentioned earlier, Central New York, Finger Lakes, et cetera, all of them meet 5 out of 7 of the criteria. They are lacking in testing capabilities and tracing. So when you look at that column about tracers, what we believe that number represents is the number of tracers that will be needed in each of those regions. But the thing that's important to note is we don't know at this point how many tracers there are in Central New York, for example. We just don't know that. And, that is up to, in a large part, up to localities and local governments to really push for tracing employees. So this does offer a blueprint for reopening. It does indicate, that the pause order is up on May 15th. We, are hopeful that within the next 10 days, you're going to see at least 5 regions in New York be able to reopen if they can, increase their testing and contact tracing capabilities. And if we could go to the next slide, that would be great.
Hey, Katie, real quick, just back to this conversation you and I had earlier this morning. We were just talking through it. So I think it's useful to think of this for our, the people on the webinar, that regional approach is a requirement in order for a region to be open. But there are 2 other pieces to this. There's the industry approach that we've talked a little bit about. What are the common features of your industry? And, are you ready as an industry, as a group, higher education or, healthcare, whatever your industry might be, to reopen, partially, and sort of ramp it up the ladder, if you will. And then the third thing is the thing that Adam was just talking about, which is a more individualized approach within your region, if it's open, and within your industry, whatever the best practices are, looking as well at, your individual business and what your situation is, your specific risks, your specific advantages, those sorts of things.
Yeah, and that really falls into nicely into this section, it's about the phases of reopening. This is where it's going to be very important for all of you basically to be listening to what Adam said about how reopening is going to happen. This is where it's going to be very important for you as an industry to have advocates, advocating for you on both the state and local level, saying that our industry is ready to reopen. Sending in letters to the Empire State Development, saying that this industry, are going to follow XYZ protocols throughout the industry. And we've done that now for a number of clients, and sent that into Empire State Development throughout the state, in each of their regions. So looking at these phases of reopening, you have the first phase, it's construction, manufacturing. That we'll just focus on that right now. Those are, as the governor has stated, they're important industries, and they are low infection risk industries. So that is, something to constantly be thinking about. How are we going to be lowering the infection risk in our workplace? And then you move to phase 2. We don't know how long each of these phases is going to last for. It could be 14 days. It could be a month. We just don't know. And we also don't know if each of the, that these phases aren't necessarily set in stone. There are things that could easily change between each phase. Phase 2, you're going to see professional services, but we're not sure exactly what professional services means at this point. Professional services can, it could feasibly be anybody with a license from the state to operate, but we just don't know at this point. And we are hopeful that we'll find out with some more guidance in a few days. If we could go to the next slide, that'd be great. And all right, so the last 2 phases, restaurants, food services, and then phase 4, arts, entertainment. And what's important there is education. This shows that how this demonstrates how much that this situation is fluctuating. Education has constantly, according to the governor, been tied to how reopening will occur, saying that in order for businesses to go back, education has to, schools have to be open. That is obviously changing at this point. And we're not sure, where, camps will fall in that. We're not sure where summer school will fall in that. But that is, again, this situation is changing, and not just every day, but every hour. Others, we're trying to coordinate with other states. And so far that's, there haven't been any broad announcements from other states in this, regional coalition that they're going to follow New York's metrics. That remains to be seen if Connecticut and New Jersey especially will jump onto that. But I think really that's, those are the biggest updates from Albany right now. And next week it could all be wrong. So we'll see.
Katie, thanks. Yeah, very fluid situation. There were some questions about, I think it's fairly stated, the interplay between the current pause order and returning to work, and some confusion about, we're an essential business, so what does it mean to say that we could reopen? And I think the answer is we have to view these things together. That for purposes of the no in-person operations, you're an essential business, which allows you to have some in-person personnel. Everyone should work from home to the extent they can, and to the extent that they're not necessary to perform those services, people would not be in person. I think what's envisioned here, the financial services industry, for example, as you bring people back into the workplace beyond where you are now, that would be part of phase 2. That would be part of the region being ready to reopen, and that would be part of your own individual plan to make sure it's safe.
And for what it's worth, the New York Times sent out a letter today to all of its employees saying, we're not expecting to bring you back into the office until September. And that's, the New York Times media is listed already as an essential service, but they aren't planning to bring people back until September. Not saying that that's the plan that everybody should follow, but, really start thinking about and continue to think about, I know that all of you have been, how people can continue to work remotely to the maximum extent possible.
Great. Okay, thank you. Let's go to Jeff. Jeff Shear is a partner in our Syracuse office. Jeff has been updating us periodically on the loan and relief issues, and it seems that that's another area that's changing very rapidly. Jeff, take it away.
Thanks, Pete. It's good to see everybody. So I want to talk about the kind of recent development with the Paycheck Protection Program and the safe harbor date of May 7th that has come up. So just backing up a bit, when applicants submitted their application on the Paycheck Protection Program. It included a certification that the current economic uncertainty made the loan necessary to support ongoing business operations. And I think looking at that certification at the time it was made, in conjunction with the requirement under the SAFE Act, or maybe the lack of requirement under the SAFE Act, that there's no other capital needed. You didn't have to see if you had other monies to support your operation during the time. That certification, coupled with that, no other capital needed, really made it somewhat easy for a lot of borrowers to make application. And I think that what happened is that in the past week or so, or I think it was about a week and a half ago, that about a week and a half ago, you saw a lot of public companies who all of a sudden it became known that they received paycheck protection monies. And these were well-capitalized companies. And we saw comments from US Treasury and SBA that those companies probably couldn't make the certification that they made. And then what happened is the SBA issued a frequently asked question and answer, Q31 that people are talking about, that kind of expanded on that original certification. And that expansion was that a statement that the current that you had to reassess your current business activity and then assess whether you had access to other capital that wouldn't be detrimental to your business if you access that other capital. And this really threw a curveball at a lot of borrowers. The curveball being, when I made the certification back in, let's say, April, it was clear that I could make the certification that the current economic uncertainty made the loan necessary. But now I need to look at my current business activity, now that I've got a month under my belt since making that application, and determine whether I have access to other capital that I can get to in a way that's not detrimental to my business. And that really, like I said, it threw a curveball in. And what I think businesses need to do, who are recipients of these loans, is look at their current business activity now, because as I started with, we have until May 7th, essentially, for you to look at your current business activity, your other capital, and make a determination as to whether maybe you really couldn't have made the certification when it was made, and then you have a safe harbor until May 7th to return the monies. So that's why we're in a little bit of a rush here with this determination. So what I'm suggesting that people do is really take a look at your current business activity. Look at what's happened, not only when you made the application, but also today. As of the end of April, as of May 5th, look to see what's happened with your sales, with your cash on hand, with your inventory, with your suppliers, with your receivables, your collections, any way that you measure your business to see if you can honestly say that your current business activity has declined since you made the application to today. And then secondly, taking a look at whether you do in fact have access to other capital. Now, this is a pretty loaded question. There isn't great guidance on what other capital means, but what you should be looking at is whether you have a line of credit, whether accessing that line of credit wouldn't be detrimental to your business long term, whether you have access to other loans, whether you have shareholders that have the capacity to make a capital infusion into your business. I saw a question pop up about whether you should be looking at affiliated entities, a parent entity perhaps, and that could be a source of other capital that should be looked at. But I think other capital, you have to remember, needs to be looked at in the context of whether accessing that other capital would be detrimental to your business. One of the items to assess when you're looking at that is that if you didn't have the paycheck protection monies and you had to use the other capital within the next 8 weeks, but then you experience a significant downturn in, let's say, late summer or fall, where would you support that downturn? So I think that it's pretty much, I hate to say it, but there's not great clarity, which has been a problem with the CARES Act and with the Paycheck Protection Program on this issue. But I think each case has to really be looked at on its own as whether there's capital to access to support ongoing operations. So then the question becomes, or really comment I have again is, what should you be doing now to really document the need that you have for the Paycheck Protection monies? And what I would suggest is taking a snapshot of your business, both as of the date you made the application and as of the end of April, to show what your current business activity is and compare it to show that there has been a downturn, that you do need these monies to support ongoing operations. Make sure you have that file ready. Any borrower that receives in excess of $2 million will be automatically reviewed when they ask for forgiveness. Any borrower under $2 million, I'm not suggesting that you have no chance of being reviewed, but it's absolutely possible that there's a review and audit on your use of those monies and whether you qualified to receive those monies. So I'm really recommending that everybody keep a file together so that if there is an audit, it is readily accessible and you're not trying to recreate a document trail. The other thing I think borrowers should really take a long look at is the intent of the Paycheck Protection Program is to rehire employees, restore wages, keep people on your payroll. If there are people that you have furloughed or laid off prior to receiving the monies, think about bringing those people back, perhaps earlier than you anticipated or earlier than needed even, to restoring wages, to use those Paycheck Protection monies for the intended purpose. Because if you don't use it for payroll and rent and utilities and mortgage interest, you're not going to get forgiveness on it. And it really, becomes an unforgivable part that has to be paid back. So why not use it for the purposes for which it was intended? So that's the real summary I wanted to give today. I think, if borrowers are on the fence, we can kind of go through what you should be thinking about. I think in my experience over the past past week or so, as I've talked to a lot of borrowers about their current business activity and access to other capital, in most cases, it's become clear as to whether dollars should be kept or whether the money should be returned. Once you kind of go through and assess the situation. So good luck with everybody. If any questions come up, feel free to reach out. Thanks, Pete.
Jeff, thank you. And I'll give you my quick takeaway based on what you just said. You basically got 2.5 business days left to make this decision. We're certainly available, ready to help you with that. And I know that Jeff's team will move heaven and earth to get back to you. But those two snapshots that Jeff mentioned and that analysis, probably better to do it sooner rather than later, given how short the time is. So thank you, everyone, for being with us today. Hopefully this is helpful information. We covered a wide range of topics. We're going to continue to do this up through early June and longer if need be. Everybody stay safe out there, and we'll talk to you soon. Thanks.